Hi! In this segment, I'm going to briefly describe how a civil case works its way through the court system. It is useful to have this information as you begin to read cases for class, because where the case is in the system determines what procedural rules courts apply to reviewing that decision. A civil case starts with a complaint, a document filed by the plaintiff, the person who's bringing the suit, and briefly describes the factual background and the legal reason the plaintiff believes they are entitled to win in court. A complaint will also include information that helps the court understand that it has jurisdiction over both the parties in the case, as well as the legal claims. Once the plaintiff files the complaint, the party being sued, the defendant, must respond to that complaint. That response might take one of two different forms. First, the defendant may move to dismiss the complaint. One common type of motion to dismiss argues that even if the court accepts and believes all the facts that the complaint alleges, that's not enough to meet the legal requirements to win. In other words, the complaint fails to state a claim upon which relief can be granted. If the court grants the defendant's motion to dismiss, it might give the plaintiff an opportunity to revise or amend their complaint to fix the problems. If not, then this decision effectively terminates the case, and the plaintiff can appeal that decision to the appellate court. If the defendant decides not to move to dismiss the complaint, or if the court denies that motion, then the defendant must answer the complaint. An answer provides the defendant with an opportunity to admit or deny each of the facts alleged in the plaintiff's complaint. The answer might also include affirmative defenses. An affirmative defense essentially means that even if the plaintiff's allegations are true and meet the legal standard, the defendant has facts that negate any liability. One example of this is the statute of limitations. Normally in civil suits, a plaintiff only has a certain amount of time after they were injured to sue, for example, 3 years. So in their answer, a defendant might allege that the plaintiff waited too long to sue, and thus even if they should win factually, the defendant cannot be liable. After the defendant files their answer, the parties engage in what is called discovery. Discovery is essentially an information exchange between the two parties, and it can take several forms, like exchanging documents, otherwise known as production, asking each other written questions, otherwise known as interrogatories, or taking the testimony of parties and other witnesses outside of the court setting, otherwise known as depositions. The court oversees the discovery process and sets a time limit for it. Discovery can take anywhere from a few days to well over a year in highly complex cases. At the end of the discovery period, either or both parties could make another motion, this time for summary judgment. The party moving for summary judgment is arguing that, given all the facts that have been discovered, there are no disputes of facts that are material to the case, such that the outcome could go either way, and thus the court could make a decision in the case rather than sending it to a jury, meaning there is no need for a trial. You see, jurors are tasked with deciding facts and evaluating the credibility of witnesses. So if there are no facts in dispute, then there is no need for a jury. Alternatively, a motion for summary judgment is appropriate if only an issue of law is at stake. That's because only judges can decide questions of law. For example, whether a certain law applies or how it should be interpreted. Jurors never decide these questions. Note that unlike the motion to dismiss I discussed earlier, there can be cross motions for summary judgment, meaning that both the plaintiff and the defendant can ask for this relief, and the court will respond to each of those requests independently. The court might grant one or the other, or it might deny them both and send the case to trial. If the court grants a motion for summary judgment, and that motion covers all of the issues in the case, then that effectively terminates the case, and the losing party can then appeal. Assuming either no summary judgment motion, or that the summary judgment motion has been denied, the case will then move forward into trial. Generally, civil trials are by a jury, although the parties can agree to have a judge serve that function. At the end of the trial, there'll be a verdict, a decision by either the judge or the jury. After that verdict, again, either or both parties may file some post-trial motions that the judge will need to decide. Two of the most common post-trial motions are a motion for new trial, where the moving party argues that there was some mistake in the way the trial was carried out that made it unfair and there needs to be a do-over, or a motion for judgment notwithstanding the verdict, that you'll see often abbreviated as JNOV, where essentially the losing party is asking the judge to throw out the verdict in the case and instead rule for them. Now, if there are no post-trial motions, or those post-trial motions have been denied, the losing party then can appeal to a higher court. And just as with the summary judgment motion, there could be cross appeals here if a party is lost on one issue but won on the second issue. Then the case will continue up through the appeals process. At this point, the labels of the parties may change, which is important to note. So whereas in the trial case the parties are called plaintiff and defendant, in an appeal it might be the appellant, which is the party appealing, and the appellee, the party defending the lower court's decision. So as you begin to read civil cases for class, identify where that case is in the process of adjudication. And if you're reading cases, it's most likely because one of three things happened. A motion to dismiss was granted, meaning the only facts considered were the ones the plaintiff alleged in their complaint. A motion for summary judgment was granted, meaning that all the facts were in after discovery and the court found an insufficient factual controversy to send the case to trial. Or the parties went to trial and a final verdict was issued, and the party is asking for a different judgment or is otherwise appealing the case. So when you are reading cases, just make sure you understand where in the life of the case your case is, and whether it is still at the trial court level or at the appellate court level, as we discussed before, because both of these things will help you know what rules the court will apply in making its decision.